Hello, everyone, and welcome to another episode of In Chambers with Mohammed Bigamy. My name is Anne Kariuki. I'm a legal assistant here at I'm joined today by my colleagues, Devlin Rioba, equally a legal assistant, and James Ndumia, a legal assistant as well. Today's discussion focuses on one of the most debatable questions. In the corridors of justice, in the corridors of the Kenya School of Law, we would know we were recently there, just last year, and in most conversations that touch on succession and inheritance law, the interpretation and application of Section 3.5 of the Law of Succession Act. Today's conversation, Rioba and James will unpack the various strands of the interpretation of this amendment since its enactment and the subsequent years. They will address the legal tensions, the practical implications, and unresolved questions that continue to be part of these conversations. Now, before we move into the gist of our conversation, I think it is best that we appreciate the context in which we're having this discussion, and that is succession and inheritance law. Succession and inheritance in Kenya is governed by the Law of Succession Act. And to briefly touch on the act borrowing from its long title, the Law of Succession Act was an act of parliament enacted to amend, to refine, to consolidate, importantly, all the laws on tested and intestate succession, as well as the administration of estates of deceased people. For those who perhaps may not be familiar with these terms, tested succession is where a person dies but leaves a will that dictates how the rest of his estate is going to be distributed among his beneficiaries, and he will proceed to define them or to provide them in the will. While on the other hand, in intestate succession, a person dies but does not leave a will that defines how what he had, the property he had, and all that is in his name will be distributed among his beneficiaries and whoever he would have those things go to. And then subsequently, administration of the estate. Now that's post-testate and intestate succession. What happens to the estate of the deceased? That's basically administration. And this is what the Law of Succession majorly provides on. And if you look at the Act true to it, it's majorly divided in three broad sections. The first part of the Act covers testate succession, speaks to the wills, validity of wills, interpretation of wills, and all that under testate. Then the Act proceeds to talk about intestate. What happens where a deceased person has died and has not left a will behind? Who do we know who are the dependents or the beneficiaries of this person? And how do we divide what he has left behind among them equally and justly according to the law? And now the latter part of the Act usually covers now the actual administration, from the procedures of getting a grant, because in both instances, intestate and intestate, you need a grant to administer the estate of a deceased. If someone dies, you can't just wake up and take over his property and decide what to do with that. That's actually an offense under LSA. So it's against this backdrop, this discussion of inheritance and succession, that we're having the conversation we're having today. The Law of Succession Act was enacted in 1972, but it was only commenced in 1981, July 1981. And then later in that year, 1981, in November, Parliament amended Section 3 of the Law of Succession Act to include subsection 5. The provisions of subsection 5 are the core of what we are talking about today. So allow me, I'll proceed to read the provision of that act verbatim. Notwithstanding the provisions of any other written law, a woman married under a system of law which permits polygamy is where her husband has contracted a previous or subsequent monogamous marriage to another woman, nevertheless a wife for purposes of this Act, that's Law of Succession Act, and in particular, Section 29 and 40 thereof, and her children of these wives are accordingly children within the meaning of the Law of Succession Act. Now, with that said, and with that in mind, Rioba, would you kindly take our listeners through the genesis of this amendment, Section 3.5 of the Law of Succession Act?
Thank you, Ms. Anne, for the comprehensive introduction to the genesis of the Law of Succession Act, its application, as well as the scope. Our dear listeners, having fully appreciated the full flavor of the introduction as presented by Ms. Anne, the genesis of this particular Section 3.5 was informed by the earlier cases, the most celebrated cases in family law as well as succession law. That is the case of Ruenji as well as the Ogola cases of 1977 and 1978. Allow me to begin by the 1978 case of the Ogola case. Just to lay a brief background of the facts, is that one man named Boza actually married under the African Christian Marriage and Divorce Act. And then he later on married one female named Bona under the Luo customary marriage. Later, of course, tragedy struck, and this man Boza actually died. What was left was then to determine who the rightful heirs of his estate were and what interest, if any, each of the heirs actually had in this particular estate of the deceased. The public trustee, as you understand, who is the default administrator in case where there is no maybe appointed executor or administrator in place, actually petitioned the court to determine these particular twin questions. The court then, that is Lord Simpson, agreeing with Sachdeva in a Ruenji case, actually opined that because at that time we had section 37 of the repealed Cap 150, that is the Marriage Act then, which did not contemplate a man who was already married to procure a subsequent marriage, then Bona was consequently locked out of any inheritance rights which would have attached. So the court took a restrictive approach because it applied the applicable law then, that was section 37. Same case as to Ruenji, because facts were similar. It's a man marrying under the African Christian Marriage and Divorce Act, later on procures a subsequent marriage, then he dies. Because of the Marriage Act which subsisted then, actually the court now are saying you cannot marry subsequently. Yes, that is the genesis of this particular section 35.
Thank you very much, Robert. I understand you to mean that in both instances, the courts ruled that since both men had married under a system that allowed only for monogamous marriages, and they subsequently contract other marriages, in both instances they were customary marriage, then for that reason, these second marriages were not valid marriages, and as such, the women in these cases, in each of the customary marriage, were not wife for purposes of succession and could not inherit from their respective husband.
Absolutely. That is what Justice Simpson rather and also Justice Sachdeva are actually saying. Then based on these particular case laws, Parliament, informed by this particular jurisprudence, which was stemming from courts, in November 1981, through the Statutes, Repeal and Miscellaneous Amendments Act, actually amended this particular Section 3, as you rightfully pointed earlier, to now cater for these particular women who were disadvantaged at that time. So Section 3.5 then, we begin to see that it was a restrictive remedial approach which tended to shift from the jurisprudence that was coming from courts to now cater for these particular women who found themselves being married under a system allowing for polygamy, which we shall see later what this system is actually about.
Okay, thank you very much, Robert. James, I understand you're of a different view as far as the mischief as it was then and the steps that Parliament took in a bid to address that mischief. I believe you consider the mischief to be much bigger, much broader, and equally inadequately attended to or remedied by Section 3.5, the amendment by Parliament. Please take us through your point of view.
And thank you very much. You are indeed right that I do take quite a slightly different view of what the mischief is that necessitated Section 3.5 of the Law of Succession Act. Not to contradict my colleague Rioba here, it is common knowledge now that what necessitated Section 3.5 is actually the holding of the two very well celebrated cases in Ogola and Ruenji. But when I look at the issue now in a wider perspective, I do realize that the mischief is actually bigger than the plight of women who are married under African customary law. Because you do find that in our society, even today, you have men who are taking on women in unions that either resemble marriage or are marriages, but they are somewhat void or invalid. But nonetheless, they take on these women as second, third, fourth, informal, formal, irregular, or regular marriages. Now, for me, the mischief then becomes quite bigger, because we should really be focusing on the plight of all those women whom the law doesn't recognize as wives under the Marriage Act. Because as you read through the Marriage Act, you're going to see that what constitutes marriage is very, very delimited, so that you find that other unions that this particular man may have are not really recognized in law. And that became a problem in succession. So then, therefore, the conversation will have to shift between the protection of one category of such type of women who is married under African customary law to now focus on the greater scope of all this type of women, whatever their union might be. It might be that it was a failed second marriage, or it might be a come we stay, or a presumed marriage. It doesn't have to matter. What matters is that all these women who have dedicated their time, their resources, their opportunities to be with this man ought ideally, and as a matter of justice, to be catered for in succession. So I think, therefore, what I consider to be the mischief of Section 3.5 is somehow quite expanded than is mainstream, or as acknowledged as my colleague Rioba here has stated.
Okay. So just to clear this, on one hand, Rioba, you're of the opinion that Section 3.5 was intended to protect women married in a system that allow polygamy, which is customary in this case, who ended up being disinherited, because the law would then be on the side of the monogamous marriage, whether it was contracted previously or subsequently. On the other hand, James, you believe that Section 3.5 should have afforded this same protection to a wider scope of women, as long as a woman had a union, as you say, that resembles a marriage, dedicated time and resources and whatever to a man. Then upon the death of this man, she as well should stand a chance to inherit from that estate, to be treated as a wife. Okay, we'll unpack this some more as we go along. Now, Rioba, immediately after the amendment of Section 3.5, how did court interpret this section now in succession disputes, as opposed to what we were seeing in Ogola, Ruenji? Immediately after the amendment, Section 3.5, what was court's approach when it was faced with such scenarios?
Having seen that indeed Section 3.5 was a restrictive remedial approach to cure for whatever mischief that had been created because of the twin cases of Ogola and Ruenji, we begin to see now courts actually starting to apply this particular provision. First, what comes to mind is the 1986 case of Reuben Nzioka. In that particular case, if I may lay the brief facts, is that one Reuben had actually married again under statute. He had married Teresia under statute law. Then later on, he actually married one Josephine under customary law. Of course, Reuben Nzioka died. Then subsequently, there was a petition as to the grant of the letters of administration of his estate. Again, the court, we see, is faced with similar questions as we had seen in Ogola and Ruenji, who are the rightful heirs, or rather beneficiaries of his estate. Because on one hand, we have a woman who had been earlier on married under statute. Then subsequently, we see Josephine now being married under Kamba customary law. The court then, that is Lady Justice Aloch, is actually interpreting this particular provision. She starts by unpacking who a married woman is, as contemplated under that particular section, and which particular system is this that is in contemplation of Parliament in 1981, November to be specific. Yeah, so the court is saying, one, you must pass 3 tests according to the courts. One, you must be married, in that there must have been a marriage which has been solemnized. Secondly, is that it is a system of law which allows for polygamy. And for this, the courts gives an answer that a system which allows for polygamy is a system under customary law. So these are customary wives. Then thirdly, which I find it quite rather per incurium, is that she now says that the operative clause, if you take married woman as well as a system allowing for polygamy, we now introduce a third limb, which is you must have been neglected. You see? She's now saying, one, you've passed the test that you are married. Then secondly, is a system of law which allows for polygamy, which according to the Lady Justice, which is correct that it is a customary law, marriage. But thirdly, is that you must have been neglected. However, that was the decision of the court. Then in 1996, we see the case of Irene Njeri Macharia. It is a Court of Appeal judgment. In this particular case, first, of course, the courts in Obita, it's kind of discussing Ruben Zioka in 1986. The court is saying, in 1986, we already have the Law of Succession Act. It provides this way. The court found it difficult to reconcile the ratio of Justice Aloch to the provision of 3.5. However, the court actually says it must be understood the genesis, or rather the applicability of this particular section 3.5. According to the court, we must answer the question, who's a married woman, again, and what is this particular system of law which allows for polygamy? And in Irene Njeri, we can see that the court there is saying that if we take an example, if we are to say that the section 3.5 actually caters for all women, then taking an example of a woman who has been married under statute, that particular woman cannot benefit from the provisions of section 3.5 because a marriage under statute is not a marriage which actually allows for polygamy and which resonates well with section 3.5. So those are the immediate decisions that actually stemmed from courts post the amendment in 1981.
James, it appears immediately after the amendment of section 3.5, court proceeded to afford this protection as Parliament intended as under section 3.5 to women who had contracted marriages with men who had either previous monogamous marriage or subsequent monogamous marriage. These women who were married in a customary system found protection under the law, and in like Irene Njeri, they stood to benefit. They were treated as a wife for the purposes of succession, exactly as Parliament intended. Now, over the years, this interpretation has not remained consistent. What began, or rather what was anticipated as a measure to afford protection to women married under customary law, has now been expanded to protect anyone who the court will find that was a wife at any time of a deceased's living. The man who has died at any point, if this woman is found to have been their wife, it does not matter under what system, then it appears they have been considered wives. Please take us through this new strand of interpretation, this expanded scope by the courts.
And you're very right on that very respect. And to proceed from where my colleague Rioba has left, following the enactment of section 3.5, there was a period there of consistency in which the courts really stuck to the letter of the law, in that they only afforded protection, or they only extended that protection of section 3.5 to women who fit the description of a woman who's married under a system of law that permits polygamy, where the husband is now contracting a monogamous marriage either before or subsequently. But towards the turn of the century, we get to see that the courts are expanding the scope of the protections afforded by section 3.5 of the Law of Succession Act. We can begin this conversation by the expansion of the protection of section 3.5 to at least women who are under a system we call it come we stay, or in law we call them a presumption of marriages, where a man and a woman are living together unmarried, but they nonetheless carry themselves as husband and wife. When the court is faced with such a challenge of how to treat this woman, ideally such a woman is not afforded protection by section 3.5 in any way or form in terms of succession. But the court, in exercising its wide discretion to promote justice, you find that it's extending that protection of Section 3.5, which strictly is limited to women married under African customary law. You then proceed where the court is also expanding the scope to women who cannot really prove that they were married under African customary law. You remember Rioba gave the conditions that earlier courts had determined for a woman to prove to the court that she ought to be given protection as a woman married under African customary law. But for example, you take the case of Thiga versus Thiga. For example, you find the court is trying to say, the very strict rituals that accompany the ceremonial African customary law marriage is not really important to answer the question whether this woman is married under customary law or not. So you find that the strict nature in which the earlier courts had really reinforced in Section 3.5 is being peeled away slowly by slowly. Moving forward to 2026, for example, we find that now Section 3.5 is being treated as a free-for-all. As long as a woman can prove that she was in the company of a man for a very long time in something that we would, let's call it a union, that somehow resembles marriage. Regardless of whether this man was married previously or not, you are finding that the court is treating such a woman or is affording such a woman the protection of Section 3.5. So that now the expansionist scope of Section 3.5, as my colleague Rioba said, it has shifted from 1981 to only cater for a very small subset of category of women we call women married under a system of law that permits polygamy, to now to cater for, we would say, all types of women who are, let's say, in a union with this man. And the court is just basically saying, treat these women as wives, as you would treat them to be, let's say, legally married wives for purposes of succession.
Rioba, what do you make of this development of law, this new, what James called the expansionist interpretation, and to other cases that have remained to what I termed as the purer, the strict letter of the law of Section 3.5? Are there courts and decisions that have remained true to that letter of the law, or are we all now conforming to this expansionist approach?
Thank you, Anne. Thank you, James, for that comprehensive submission. To answer your question, yes, indeed, there have been cases which have remained true to the literal interpretation of what Section 3.5 is. In particular, allow me to discuss the case of Phyllis Karanja versus Rosemary Karanja. In this case, we can see the court is saying that you cannot countenance a presumption of marriage because it is not a system of marriage. At least we know that systems of marriage, we know them to be 5, as we shall expound later on. Also, allow me to discuss the case of Mbiu Koinange, especially the jurisprudence of the High Court. What the High Court is saying, if you take, for example, a presumption of marriage, or for the benefit of our viewers, in Mbiu Koinange, of course, we understand that the late Mbiu Koinange actually had 4 wives. So, from these 4 wives, there arose a dispute when Mbiu Koinange actually passed on. The disputes actually mainly revolved around the 3rd house of Margaret and also the 4th house of Edda. The court, faced with this particular similar set of questions, is saying, for example, for Edda, who we are saying that lived for a long time from 1971 with the late Mbiu Koinange until the point of his death, if we are to presume presumption of marriage, then we must understand the backdrop of this particular presumption. As you understand it, it is a common law import. Common law is basically judgment law. And for this particular common law kind of marriages, which are basically presumption of marriages, the court is saying it is based on a Western model. Under the Western model, Family Law 101, our understanding of our marriage is that it's a voluntary union between a man and a woman to the exclusion of the whole world. That is basically the case of Hyde versus Hyde. And based on this particular definition of what a marriage is, then we cannot countenance having a presumption of marriage as well as an existing marriage. Basically, what 3.5 is saying, because 3.5 is saying there is already an existing monogamous marriage or a subsequent monogamous marriage. So in Biu Koinange, the High Court is saying we cannot countenance that. However, you can see, of course, the case was appealed. The Court of Appeal, relying on Irene Njeri Macharia, rightfully interprets what this particular section 3.5 is. It points out that it came in to cover, or rather to protect, the women who are married under customary law. However, the court is saying, given that already this particular court has already decided in the case of M&M versus DKMN, then we are to extend this particular provision to cater for these particular women. Same case to what my friend was saying, the most recent case. In Dolo Msimi, we can see that most recently the court is saying we interpret section 3.5 to mean that these are women who are married under customary law. However, the court now shifts or rather vacates from this particular interpretation of the law, where it says that now this particular provision caters for all cadres of women. Then it leaves us what particular law is the court interpreting. Same case in Lihasi Bidali. We can see in Lihasi Bidali, the Court of Appeal is bringing in a different cadre of women who it calls beneficiary widows, despite having correctly interpreted who a wife under section 3.5 is. We both agree that the High Court has been on point. The Court of Appeal kinda has missed the point in that it rightfully interprets who these particular women are, but then it extends this particular protection to all cadres of women. And that's now where I take a divergent view that there ought to be a very fine line between interpreting the law and judicial legislation, because I believe the function of the court should be to interpret the law as it is. And remember, as I pointed earlier, section 3.5 was a restrictive remedial approach in that it's intended to cure the mischief that existed then. If there exists subsequent mischief, then I think the correct thing to do is to amend the law, not to extend this particular provision to cater for all these women, as the Court of Appeal suggests. However, it should not be lost that the Court of Appeal, in the case of Thiga versus Thiga, has actually interpreted who this particular woman under section 3.5 is. The court has actually picked out what is the meaning of contracting a marriage and a system of law permitting for polygamy. For you to contract a marriage, it means there has been solemnization of that particular union in either of the 5 particular marriages as we understand them. Then secondly, it must now meet the second limb of section 3.5.
James, will give you an opportunity to respond to what Rioba says and, tell us if you think the Court of Appeal is off the mark, and if not, why. We'll get back to that discussion. But before we do, I think it's time we revisit another conversation that has been coming up in the responses that we have, but we've not properly canvassed it, and that is the relationship between the Law of Succession Act and the Marriage Act. Now, the Law of Succession Act provides for succession, the Marriage Act provides for marriages. The Law of Succession Act, however, in defining a wife, refers to a wife as a spouse, and in the interpretation of the spouse, the Law of Succession Act takes us to the Marriage Act, and provides that a spouse is someone who is considered a spouse under the provisions of the Marriage Act. Now, the Marriage Act is very specific on what a marriage is, and as a result, who a wife is under each of these marriages. Section 6 provides for this systems of marriages, I could say that are recognized in law, at least in Kenya. The Christian marriage, the civil marriage, the Hindu marriage, Islamic marriage, and customary marriage, right? In the same section 6, subsection 3 is very express that the 2 systems of marriages that they could recognize to be polygamous or potentially polygamous is Islamic marriages and customary marriages, right? However, when you come to the Law of Succession Act, Section 3.5, it appears to expand who a wife is. The provisions of Section 3.5 expand who can be considered a wife, even under the LSA. But then remember, the same LSA has already defined a wife by taking us back to the Marriage Act. And the Marriage Act is very specific on who a wife is, which is not what is anticipated under Section 3.5. Now, Joba, do you think there's a conflict within these two frameworks?
To answer your question, prima facie, there appears to be a repugnancy between the Marriage Act and the Law of Succession Act. However, as a caveat, we should never convolute these particular statutes. One, on the other hand, regulates the law relating to marriages and divorce, and it's for living persons. The other one kicks in immediately upon the death of either, in that now it's now speaks to the devolution of the estate of the deceased. Maybe to throw spanner into the works, it takes me to the discussion we used to have in the Kenya School of Law, that is the doctrine of implied repeal. Because under this particular doctrine, as we appreciate it, in the case of Katna versus Phillips, and also here in Kenya, the case of Michael Wanderi versus the Registered Engineers Board, what this particular doctrine implies is that if, for example, we have two or more provisions of law legislating on a similar thing, then the latter act tends to abrogate any inconsistency that might have been in the initial act. An example be the Marriage Act, which we understand was enacted in 2014. And on the other hand, the Law of Succession Act, which was enacted in 1981. In that, if there are provisions in these particular two statutes providing for the same thing, and there happens to be an inconsistency, then the Marriage Act will abrogate that particular inconsistency in the Law of Succession Act. However, we ought to appreciate the wording of Section 3.5. I remember when you are reading that particular provision, it begins with notwithstanding any other written law. So Parliament in 1981 was in contemplation that there is already existing law. In particular, remember, Section 37, which you have already seen, which is a mirror, or rather a reflection of Section 9 of the current Marriage Act, as well as Section 171 of the Penal Code, that notwithstanding these particular two provisions, this particular woman who has been married in this particular system of law ought to be recognized as a wife. To that extent, it is a non-obstante clause. Some may say that it is rationalizing a nullity or something that is void, but we must appreciate the context within 3.5 is. And actually, that particular provision, that is Section 3.5, it qualifies itself in concluding that it is there for only the purposes of succession, not any other thing. So prima facie, yeah, someone might argue that there appears to be a repugnancy, but we ought to appreciate the context within which Section 3.5 operates. It is a non-obstante clause.
Thank you, Joba. James, do you want to weigh in on this question of the conflict between Section Marriage Act and Law of Succession Act as far as the definition of wife goes, if any?
And thank you for your invitation for me to contribute to this very technical issue of the intersection between the Law of Succession Act and the Marriage Act. I want to agree with my colleague Rioba in substance that indeed the two regimes of the Marriage Act and the Law of Succession Act ideally govern two different aspects of human life. Marriage Act will govern the reality of the relationship between this man and his wife or wives during the subsistence of his life. The Law of Succession Act kicks in when he dies, and the Law of Succession Act is not coming to redefine who the wives were, if you interpret Section 3.5 as it ought to, because Section 3.5 only invites the court to treat other women who are not legally recognized, nonetheless as wives. What now the Law of Succession Act is saying, women under a system of law that permits polygamy. So therefore you would come to find that for what the law of marriage provides for, the Law of Succession doesn't, because the Law of Succession Act is not trying to redefine, for example, what a wife is in the ordinary sense of marriage law. The Law of Succession Act is only coming in to say, treat these other wives or these other women who are not really recognized per se in law as wives, as you would treat a legally married wife. But the point where there is a real conflict that we ought to address is when the Section 3.5 starts talking about a system of law, or it starts talking about marriage. Because as we understand in the system of our laws, there are laws that we call lex specialis and lex generalis. That means there are laws that are dedicated to address a specific aspect of law. Let's say in this case marriage, we dedicate the Marriage Act. And then all the other laws that reference marriage are generally called general law, or laws referencing it incidentally. Ideally, that is what Section 3.5 of the Law of Succession is. And ideally, how we operate in our laws is that if there's a specific law governing a specific aspect, let's say marriage, then that law ought to take precedence. Whatever that statute provides for in very specific form should govern and should take preference over every other general law that talks about it. So when we begin a conversation that Section 3.5 should somehow be read in isolation, or that the Law of Succession Act in general operates in a vacuum on its own, and there are decisions to that effect, including in the Court of Appeal, that say the Law of Succession is a self-encompassing act, I tend to disagree in principle, because ideally, after all, each specific law in Kenya occupies a certain chapter in our books. The marriage law is a certain chapter, and so is the Law of Succession Act, rather. So that would mean, ideally, that all these laws, there's a presumption that they should cohere, that there shouldn't be any inconsistency. And an inconsistency can only be avoided if we take certain measures, for example, like taking precedence to the law that specifically governs that specific area. For example, marriage. So the shorthand of it is, when Section 3.5 is talking about marriage, ideally, our minds should focus to the law that provides for what marriage is. And that is where now the differences, at least in scope for me, begin to emerge. Because the Marriage Act is very quite specific of what a marriage is, especially in regards to what is considered a valid marriage and what is considered a void marriage. For example, if a man is married under, let's say, customary law, under Section 9 and 11 of the Marriage Act, he is prohibited from contracting a monogamous marriage. If he desires to have multiple wives, then let all the wives be married under customary law, because there's an expectation that that is essentially polygamous. So when Section 3.5 is now providing for a caveat that indeed there are void marriages, but are nonetheless regularized for the purpose of succession, there's a real conflict there that we cannot ignore. And I would not take the view that let us interpret the Law of Succession Act in isolation, because that would mean that we are relegating the Marriage Act, the very law that ought to provide for marriages, into a secondary category or irrelevant to the conversation at hand. I believe that in as far as Section 3.5 provides for marriage or the definition of a spouse, then ideally it should take us automatically, as you rightly said, to the law that provides for marriage. But nonetheless, and I want to reiterate what my friend Rioba here said, the two regimes are completely different, in that the Marriage Act will only operate during the subsistence of this man's life, to the effect that all other marriages that the Act considers void or invalid do not have any legal recognition. For example, a second monogamous marriage, the wife there, for example, would have any entitlements, at least to any marital property, any benefits that would accrue in a marriage, because her marriage is void. But you see, at least now, for when we come back to Section 3.5, the law is saying that let us treat this wife, regardless of her void marriage, as you would treat a wife, because she is entitled to some level of extent to the property of the deceased man.
James, while we are still on the intersection of the Marriage Act and the Law of Succession Act, and who is a wife under each, and what is void marriage under each frameworks, under each regimes, you'd recognize there is an offense in law that criminalizes entering into any subsequent marriage while you are in an already monogamous marriage, while a monogamous marriage you had previously contracted is still subsisting. Section 171 actually of the Penal Code criminalizes the offense of bigamy, right? Now, the provision of Section 3.5 appear to endorse this offense of bigamy because in Section 3.5 it recognizes that you might have been in a monogamous marriage, right? But for purposes of succession, if you subsequently got into another marriage, even when your monogamous marriage subsists, then this wife, in a marriage that ideally would be void, is considered wife for purposes of succession and the law of succession. Do you think there's a thin line, or what do you think are the implications of Section 3.5 when it comes to this offense of bigamy?
That is also another very important technical aspect of the stress between the Marriage Act, the Penal Code, and the Law of Succession Act. As we look at it, and as you've rightly put out, the Marriage Act under Sections 9 and 11, as well as the Penal Code, they really prohibit a man from procuring another marriage while the other one is still subsisting, unless it's under a whole customary law kind of setting. So you would expect, for example, if a woman enters into a monogamous marriage, let's say under a church wedding or at the AG's office for a civil marriage, she has the anticipation that she's going to enjoy, let's say, alone during the subsistence of the marriage, and as well as upon death, all the benefits that would accrue from the marriage. If at all they accumulated property with this husband, she would have the expectation that she alone, being the only wife, at least by the expectation brought about by being in a monogamous marriage, she would expect to be the sole beneficiary. But you find Section 3.5 is also bringing in a real stress issue, because it's also recognizing that other women are also entitled to a share of the estate. And these are women who find themselves in unions that are not really recognized in law, as we correctly put it under the Marriage Act. So you find that the offense of bigamy itself, while the Marriage Act continues to hold it void, and it should, the Law of Succession Act upon death somewhat extends benefit to also this woman who would otherwise, when the man was alive, could not have had benefits extended to him. So ideally, and again to reiterate the point, the stress only comes in after this man has passed on, and it's not coming in to regularize the criminal nature of that union. It's only coming in to request the court to treat this woman as a wife. Nonetheless, because ideally, and I believe I had given this example earlier, if a woman, for example, spends 20 years with a man and they never regularize that marriage, you would imagine the injustice that would be caused if that woman is just cast away and told that you don't recognize your marriage in law and therefore you're not entitled to inherit anything. That is a grave injustice that the courts have been grappling with, to the effect that they hold it would be unjust to treat such women, including those who are under systems we call common estates, very, very informal, to nonetheless hold that they are entitled, because ruling either way would be a graver injustice. So you find that whereas the law, the Marriage Act, as well as the Law of Succession Act, really want to protect the wife under a monogamous system of marriage, it's also recognizing the complexity of the issue, in that there are other women who would be either way cast away or not considered by the law, who are nonetheless entitled to a share of the estate. So ideally, that would be the demarcation that I would draw between the offense of bigamy as well as its intersection with the Law of Succession Act.
Okay, so bigamy persists when the man is still alive. To that extent, the marriage he has subsequently to his monogamous one is void and is an offense under Section 171 of the Penal Code. But once he passes and the law of succession kicks in, law of succession is not coming to pronounce itself on the validity of the various marriages that this man had contracted. It's coming to afford protection to all the wives who are in a union with a man, and to ensure they are adequately catered for and provided for in the inheritance and succession process. Before we conclude this conversation, perhaps someone watching might be wondering, what's the position of children in this scheme of things, in this discussion of who is a wife, who will be covered under Section 3.5? What's the place of children?
Thank you for the question. But before answering the question, allow me maybe to rebut to what my colleague has said as to the technicality between the Marriage Act and the Law of Succession Act. Because if I get you correctly, you approach this from the angle that we ought to breathe some meaning, that is, of the Marriage Act into the Law of Succession Act. It just leaves me to wonder, then what will be the essence of having Section 3.5 if we are to breathe any meaning of the Marriage Act to this particular provision? Nonetheless, to answer your question, the place of children in this whole conversation, I think it has been cited ad nauseum that the sins of parents should never be visited upon children. To this extent, allow me to borrow from the provisions, or to make reference from the provisions of the Children's Act 2022 under Section 17, which expressly states that children actually have a right to inherit. And that particular right should not be limited in any way, or no children ought to be discriminated against based on race, gender, or any other protected ground, as we understand under Section 27. And to this extent, we must understand these particular children also cover female children. We understand the case of Rono versus Rono, which actually proscribes against prohibiting based on gender. Then coming back to our discussion, that is the Law of Succession Act under Section 3, we can see we have different cadres of these particular children. One, the Law of Succession Act actually defines a child to include a child who has been conceived but not yet born, provided that that particular child is subsequently born alive. Then secondly, we have a child in respect to a female person who was born out of wedlock, or in respect to a man who this man has subsequently accepted this particular child and assumes parental responsibility. And these particular children, they all fall under primary dependence under Section 29. So for children, regardless of the status of their parents, provided that they have been subsequently born or a male person has actually assumed responsibility over them, they benefit. Because remember, Section 3.5 actually ends by saying that their children are subsequently children within the meaning of this particular act. And also, just to reiterate, recently we saw the Supreme Court actually protecting these particular children who might have been born out of wedlock. In the case of Fatuma Athman versus Ruth Faith Mwawasi, the court is saying regardless of whether this particular child has been born out of wedlock, then there are protective measures. For example, Article 53 of the Constitution of Kenya, which actually protects these particular children. So children, they occupy a very hallowed place within our legal system, and regardless of the union of their parents, they are rightful heirs of the estates of their parents.
Thank you, Rioba. I think that pretty much presents the correct position of law as far as the place of children goes in the context of this conversation, and even the wider context of succession and inheritance. Now, to our concluding remarks, perhaps your final thoughts on this subject. James, and then Rioba, you can follow.
Okay. I think it has been a very interesting conversation, and one of the things that I have been able to pick out, at least from this conversation, is that the issue of Section 3.5 is very, very complex, and it cannot be reduced to a single issue, that being the protection of a woman married under a system of law that permits polygamy. I think what I've been able to get from this conversation is that there is a wider principle that can be drawn from Section 3.5, in that a woman who finds herself in such a situation where a man has either represented or misrepresented to her that he could take her as a wife only for him to die and the woman finds herself destitute is an issue that ought to be canvassed either by extension of Section 3.5 or either an amendment thereof. But at the time that we are in now in 2026, it is reasonable to expect that the situation was not as is in 1981. In any case, we have really learned a lot from all the cases that have been coming before our courts, all the different very complicated circumstances, as you would expect in families, to really shift our mindset towards the interpretation of Section 3.5. And the Court of Appeal has really done a very good job towards shifting our mindset to that by exposing the realities and holding the fact that, Section 3.5 ought to protect women who find themselves in those positions, where your marriage may not be legally recognized in law, but you ought nonetheless to be treated as a wife, at least to get some form of justice when that man dies. So in summary, I think the courts have been right to the extent that they have expanded the protections afforded to Section 3.5, not only now to a woman married under a system of law that permits polygamy, but to also other women married under other systems of law, or a woman who would be presumed to be a wife nonetheless, so that it's now a harmonious and universal protection of women who find themselves in such positions.
Joba, as you give your final concluding remarks, perhaps you could let us know if you think the position that James has taken, which is in line with jurisprudence from the Court of Appeal, warrants an appeal or an amendment to Section 3.5, as you give us your concluding remarks.
In conclusion, this has been quite an insightful session. We have appreciated the various nuances under Section 3.5 of the Law of Succession Act. We have had a look at the genesis, that it was a restrictive remedial approach that existed then. But over time, the situation that obtains has quite changed, as my friend has rightfully pointed. We can see that Parliament has over time tried to amend the Law of Succession Act, with the recent amendment being in 2021. I wonder why Parliament actually elected not to amend this particular Section 3.5 to cover for all these kind of women. Why it chose that, I think they're best suited to answer that particular question. But however, as my friend has said, the jurisprudence coming from the courts, especially from the Court of Appeal, to me, it sounds like we are shifting to judicial legislation, which I don't think is the work of the courts. Parliament, if they think there is anything that is ambiguous, then they ought to amend the provision as it is. I fully agree that the situation has changed, and the same way the 1981 amendment was informed by the situation that obtained then coming from the courts. In a similar vein, Parliament should then be informed by these particular decisions coming from the Court of Appeal or other courts to actually reflect these particular changes in the law.
Ladies and gentlemen, that marks the end of our conversation, at least for today. Clearly, there is a lot to be said as far as this discussion goes. I want to thank my colleagues, James and Joba, for their extremely invaluable input into this discussion, the insights they have offered, and all they have shared with us. We hope there will be much more coming from them, and we look forward to having them on the subsequent episodes. And to you, our dear and very esteemed listener, we thank you also for tuning in to the conversation today. Please remember, even as you engage with the content, to like, subscribe, share, and continue engaging. See you in the next one.